Okay, so this is the case of LTFRB versus GV Florida Transport Incorporated. The issue in this case is, does the LTFRB have the power to revoke multiple certificates of public convenience of an operator when only one is involved in an accident? So the facts are as follows. On February 7, 2014, a vehicular accident occurred in the Bontoc Mountain Province involving a public utility bus with a plate number TXT872 from Sampaloc, Manila, bound for Bontoc. The mishap claimed the lives of 15 passengers and injured 32. An initial investigation report showed that based on the records of the LTO and LTFRB, the plate number TXT872 actually belongs to a different bus owned by and registered under the name of a certain Norberto Cue under the Certificate of Public Convenience case number 2007-0407, and that the bus involved in the accident is not duly authorized to operate as a public transportation. On the same day, LTFRB, pursuant to its regulatory powers, immediately issued an order preventively suspending the operation of 10 buses of QE under its CPC, as well as GV Florida's entire fleet of buses consisting of 228 units under its 28 CPCs. Thereafter, the DOTC reported that, among others, the license plate of the bus was indeed TXT872, which belonged to a different unit owned by QE, and that the wrecked bus had a different engine and chassis number, and that the bus was registered as private with a license plate of UDO 762 and is owned by the Gupan Bus Company. As a result, the Gupan Bus Company was also ordered to submit an answer to explain why its bus was involved in the accident. The Gupan replied that it was not the owner of the bus and that the owner was actually GV Florida, but the Gupan entered into a memorandum of agreement with GV Florida, which facilitated the exchange of its CPC covering the Cagayan route for the CPC of Florida, which covered the Bataan route. The subsequent registration of the bus in the name of the Gupan bus is merely a preparatory act on the part of GV Florida to substitute old authorized units of the Gupan bus plying through the Cagayan route, which are being operated by CPC, which has been exchanged with GV Florida. QA, on the other hand, contended that the license plate number TXT872 was issued by LTO to one of among 10 utility buses under CPC 2007-407, issued to him as the operator of the Mountain Province Cable Tours. The application for extension of validity of the said CPC was actually pending with GV Florida. GV Florida alleged that it bought QS, CPC, and the 10 PU public utility buses, including TXT872. And since QS buses were already old and dilapidated and not wanting to stop its operations, it replaced these buses with new units using license plates attached to the old buses pending approval of the sale and transfer of QS CPC in its favor. The LTFRB canceled QS CPC and suspended the operation of GV Florida's entire operation with its 186 buses under the 28 CPCs for 6 months. GV Florida appealed to the Court of Appeals, praying for an injunction against the LTFRB's ruling, and the Court of Appeals partially granted. The issues in this case is whether or not the LTFRB has the power to suspend the fleet of a public utility which violates the law to the damage of the public, and whether or not the suspension here is within the powers of the LTFRB to impose, and is it reasonable. The court held that yes, it is reasonable. Section 16N of the Public Service Act provides, Section 16, proceedings of the Commission upon notice and due hearing. The Commission shall have the power, upon proper notice and hearing in accordance with the rules and provisions of this Act, to suspend or revoke any certificate issued under the provisions of this Act, whether the holder thereof has violated or willfully and contumaciously refused to comply with any order, rule, or regulation of the Commission, or any provision of this Act. EO 202, which created the LTFRB, provided for the powers and functions of the LTFRB in Section 5. It provides that the board shall have the following powers and functions, among which letter B, to issue, amend, revise, suspend, or cancel certificates of public convenience or permits authorizing the operation of public land transportation services provided by motor vehicles, and to prescribe the appropriate terms and conditions therefore. In this case, GV Florida is actually guilty of several violations of the law. Number 1, lack of LTFRB's approval of the sale and transfer of the CPC bought from QA. Number 2, operating the bus under its name when the same was registered under the name of the Gupan Bus Company. Number 3, attaching a vehicle license plate to the bus when the plate belongs to a different bus owned by QA. And number 4, operating the bus under the authority of a different CPC. So therefore, there is no good faith on the part of GV Florida. GV Florida claims that it is unreasonable for the LTFRB to suspend the 186 buses covered in its CPC, considering that only one bus unit covered by one CPC is involved in the accident. The Supreme Court agreed with the LTFRB that its power to suspend the CPCs issued to public utility vehicles depends on its assessment of the gravity of the violation, the potential and actual harm to the public, and the policy impact of its own actions. The court gave due deference to LTFRB's exercise of its sound administrative discretion in applying its special knowledge, experience, and expertise to resolve GV Florida's case. The law gives the LTFRB, which was previously known as the Public Service Commission or the Board of Transportation, ample power and discretion to decree or refuse the cancellation of a CPC issued to an operator as long as there is evidence to support its claim. In a long line of cases, the court held that in the matters of this nature, so long as the action is justified, the court will not substitute its discretion for that of the regulatory agency. Another contention by GV Florida is that in suspending its 28 CPCs, the LTFRB acted in reckless disregard of its property rights as a franchise holder. In the case of Luque versus Villegas, the court held that the very nature of the certificate of public convenience is at cross purposes with the concept of vested rights. The accepted view is that a certificate of public convenience constitutes neither as a franchise nor a contract, confers no property right, and is a mere license or privilege. The holder of such certificate does not acquire a property right in the route covered thereby, nor does it confer upon the holder any proprietary right or interest of franchise in the public highways. Revocation of this certificate deprives him in no vested right. GV Florida also contends the authority of the LTFRB under Section 16N. It does not mean that the LTFRB has the power to suspend the entire operations of the transport company. The court held that the law clearly states that the LTFRB has the power to suspend or revoke any certificate issued under the provisions of the PSA whenever, Public Service Act, whenever the holder thereof has violated or willfully and contumaciously refused to comply with any order, rule, or regulation of the Commission or any provision of this Act. So it has been held that when the context so indicates, the word any may be construed to mean, and indeed it has been frequently used in its enlarged and plural sense as meaning all or every, each one of all, every without limitation. Indefinite number or quantity, an intermediate unit, or number of units out of many or of all, one or more, as the case may be, several or some. Hence, under the above definitions, the LTFRB undoubtedly wields under the law to suspend not only one but all of GV Florida's CPCs if warranted, which is proven to be the case here. That is all.